Interference with an emergency call. What is it? What does the state have to prove in order to convict someone of this crime? Hi, I'm Jeff Hampton with the Fulgham Law Firm. Today I want to talk to you about the crime of interference with an emergency call. And many times this is not a crime that people talk about very much, but you'll find that it accompanies many domestic violence assaults, domestic violence crimes as well. And by the way, if you wait around to the end of this video, I'm going to give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Now I want to jump right into this and first ask, what is required in order for the state of Texas to prove the crime of interference with an emergency call? Well, you have to look under Texas Penal Code section 42.062. It states that an individual commits the crime of interference with an emergency call if the individual knowingly prevents or interferes with another individual's ability to place an emergency telephone call or request assistance in an emergency from a law enforcement agency or other agency or entity, the primary purpose of which is to provide for the safety of individuals. Now, people say, well, when does all this happen? Well, the most common scenario ends up being when maybe a couple, a husband and a wife or roommates or whatever, two people get mad at each other and things get a little out of hand, and then one party is going to call the police potentially, and they're like, no, hey, calm down. We're not doing this right now. Put the phone down. We're not going to make a call right now. And what happens? So they end up allegedly somehow grabbing the phone or preventing an emergency call from taking place. And that information usually comes out later when the police come out and interview a witness. And what ends up happening is you'll end up having a domestic violence related offense. They'll tag on an interference with an emergency call because they believe that goes along with the crime. This is very important, by the way. If you or a loved one are facing a domestic violence crime and an interference with an emergency call case, it's real important. You cannot separate those two. If you or a loved one were arrested at the same time for both incidents, if you try to go in and resolve one case in one manner and then in another case in a different manner, it could end up preventing you from being able to get either one of them off of your record. And what I mean by that, you need to get both of your charges dismissed or resolved in the exact same manner. Let's say you were to get the interference with an emergency call case dismissed, but the domestic violence assault case you took a probation on. In that situation, you could not get either one of those cases off your record. So it's very important that both of them are fought simultaneously for a result that will allow you to get it off your record, okay? So let's talk for a few minutes about this crime. Whenever you're looking at this particular crime, one of the things you have to define is, what is an emergency, right? What is the definition of an emergency? Well, under the same section of the Texas Penal Code, emergency means a condition or circumstance in which any individual is or is reasonably believed by the individual making the call to be in fear of imminent assault, or in which property is or is reasonably believed by the individual making the telephone call to be in imminent danger of damage or destruction. Now, that's just a bunch of mess I threw out there to you to say, look, it's very subjective. So the definition of emergency is in the eye of the beholder, right? And so one of the mistakes we find that happens quite frequently is that police officers will not really get into that part when it comes to doing a statement from the witnesses. So a lot of times, whether or not it's very clearly articulated as to whether a true emergency was present or not, that's very subjective. And it's very critical that your attorney analyze that element of the offense. What if it was just someone annoyed, but there wasn't an actual emergency? If there's not an actual emergency, it's not a crime. So just because someone's interfering with someone's call doesn't mean it's a crime. There has to be an actual emergency, and that information must be presented or sufficient to be found at the time of the arrest. Okay. Now, what is the range of punishment for an interference with an emergency phone call? Under Texas law, it is a Class A misdemeanor, punishable by up to 1 year in the county jail and up to a $4,000 fine. Now, if for some reason you are facing, if you've previously been convicted for an interference with an emergency phone call, a new crime of a second can technically be classified as a state jail felony, punishable by a minimum of 180 days in jail up to 2 years in prison, which is another reason why you don't want to be convicted for an interference with an emergency phone call case, okay? Now, what are some legal defenses? I've already gone over one of them with you. I'm gonna just very quickly go through this. One of them is that an emergency was not actually taking place. As I've articulated before, what if there was actually no fear of imminent assault or damage to any property at the time? In the heat of the moment, people's tensions can be very high. When phone calls are being made, when information's being shared with the police officer, you can get emotional. Both sides can say things that later on they look back on and say, you know what, that probably wasn't very fair. That may not exactly reflect what took place. And by the way, if you have someone who originally, an alleged victim, who said that originally, and now they're coming back saying this wasn't fair, and I want to make sure that that's clear about what took place, it's important that they can provide an actual affidavit through your criminal defense attorney that can be used for your defense to help try to get your case dismissed, okay? So they have to be able to establish, the prosecutor must prove that there was an actual emergency that took place. Now, the second point is, what if you did not recklessly damage or destroy the phone? Because that's the other element to this. You could have interfered with a call or also damaged the actual property related to the phone itself. Remember, if the phone was damaged or destroyed, the prosecution must prove beyond a reasonable doubt that you did so recklessly. But what if you didn't act recklessly? What if you and the other individual were upset and frustrated with each other, and in the process, you accidentally, negligently hit the phone without the intent to knock that phone down and interfered with the call or broke the phone? In that situation, once again, those facts need to be clear and presented so that the prosecutor will understand they don't have a case. If they cannot prove the criminal intent element of any damage to the phone, then they're not going to have an opportunity to be able to convict you of the crime, all right? What if you were not the actual cause of the damage to the phone? So in other words, what if the phone was damaged, but you weren't the actual cause of it at all? What if you were in a heated argument and during the process of that, the alleged victim dropped the phone and the police attributed that to you? You notice how in the heat of the moment, everybody wants to try to put blame on the other person. And then later on, you can kind of look back on it and say, boy, I regret that. That is not the way that this took place. These factual issues can be cleared up, and that can make an enormous difference in whether or not you should have ever been charged with a crime. Finally, what if you had no knowledge that there was an actual emergency phone call taking place at all? What if you thought that individual was speaking to someone else? What if you thought they were calling their mother or their father or calling someone else, and you had no idea that there was an actual emergency call taking place? Remember, the state of Texas must prove beyond a reasonable doubt that you knowingly prevented, that word knowing, you knowingly prevented or interfered with another individual's ability to place an emergency phone call or to request an assistance in an emergency from law enforcement or medical. Okay. Now, if you had no idea that that individual was attempting to make an emergency call, then your attorney is going to have leverage to argue that you did not act with criminal intent required under the law. Now, one of the questions an aggressive criminal defense attorney should ask is, how many other witnesses were present? Was there a third party that was present that could provide a sworn affidavit that helps clarify some of these points? Because even if the alleged victim's not willing to provide that information, other witnesses that were present at the scene could help clear that up. Your criminal defense attorney should get with those individuals, provide affidavits, use that for your defense. These are some basic investigation strategies that can be used to help you if you're facing an interference with an emergency phone call case, okay? So listen, I've just given you a basic overview of the crime and to understand what it is. But don't neglect this. I want you to understand it's still a Class A misdemeanor. Some people think it's not that big of a deal. But if this is not handled properly, you can end up with it on your record, and it could still be up to a 1 year in county jail, okay? Now listen, I want to invite you to subscribe to our YouTube channel. If you liked what you heard today, subscribe to our channel, like this video. I also promised you I'd send you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link down here below. If you are in the North Texas area, you are a loved one, and you need help with a case like this, don't hesitate to contact the Fulgham Law Firm at the number you see right above me right now. We'll be happy to give you that free case analysis. I want to thank you for joining us here today. We'll see you on our next video series.